Afternoon, everybody. Welcome to Heinz's usual Thursday afternoon webinar. I am Chris Irons, former Commissioner for Body Corporate and Community Management, Australia Advisor with Heinz. With me, as always, Frank Higginson, partner at Heinz. Frank, welcome.
Hello, everyone, and thank you for joining us for what's well, I suppose, novel, unique, you'd almost say, boutique topic.
Very boutique. If we accept that body corporate law is pretty boutique and niche, then this is boutique within boutique, because this week we're talking about the mysteries of BUGTA. Before we get into that, as always, don't forget to like and share, get the message out there. We find out what topics people want to hear about. And you can pose questions to us today, just questions on the Facebook page, and we'll get through those as we go along. But BUGTA, it's a weird kind of word. It suggests some kind of flapping insect with a proboscis, or perhaps a virus or something.
Yeah.
Well, yeah. I do wonder what the layperson thinks when they hear the word BUGTA. Frank, what's a BUGTA?
BUGTA. I did send a letter to a client at one stage, probably about 6 months ago, where she's in a BUGTA scheme, and she came back to me saying, "Frank, I don't understand anything you're saying with your acronyms." And so it's like, okay, sorry, I'll slow down. So BUGTA is the Building Units and Group Titles Act from 1980. So I suppose we're going to talk about history, might as well rip in, because this is actually relevant, I suppose, in terms of it's why do we still have some bodies corporate that are caught by this legislation and caught, trapped, have it imposed upon them. I don't know, whichever way you want to look at it, subject to where you are in the body corporate structure. But you go back to before even BUGTA, there was very limited piece of legislation. Before that, we used to have company title to do strata title. There was no strata title. So what would happen is Irons Towers would own a building, and there might be 10 lots in there. And what would happen is I would own share certificate 1, and that would give me the right to occupy lot 1, sell it, transfer, and when you sold it, you actually sold your share in the company that owned land. Sure. So we've obviously come a long way from there. Company title is well, in Queensland, it's a process to get rid of, but I think most company title buildings have now moved across towards being BCCM. But the evolution of strata title legislation really, I suppose, started in a big way with BUGTA in terms of here's development. We need to have regulation for bodies corporate as opposed to corporations law, which is the only other way to deal with share certificates. So at that stage, people would have AGMs, directors, raise levies from owners in terms of imposing on shareholders as opposed to levies and so on. So BUGTA arrived in 1980. Probably say it was groundbreaking at the time, as much as I was still in school. Although I will say, Chris, and shows my age here a little bit, first 5 years of my legal career was under BUGTA. So 92 to 97. But one of the issues with BUGTA, we get a little bit deeper in terms of the history, is that it was really inflexible in terms of development. So what it did was effectively create a management regime for running bodies corporate, so levies, committees, owners, general meetings and so on, and bylaws, but it was really inflexible when it came to stage development or the type of developments that we've really got going on today. Just really, it didn't work. So old school, and Adelphi Springs is the example that always comes to mind for me for this one. That was a Raptors development on the Gold Coast in the early 90s, and it had 8 separate bodies corporate that got developed in individual stages. And even though they had common pools and the rest of it, those bodies corporates were linked by easements and access agreements and co-contribution agreements and all sorts of things, because the Act didn't allow a stage development, which BCCM does. But of course, with the 80s, I suppose, we come back to the Japanese investment boom and all that sort of stuff. Vast tracts of land were being turned into developments with tourism resort status and special FIRB rulings to allow foreign buyers to sell and resell. And the first one of these really is Alunga and Balla in Surfers Paradise, which was Kornhauser. So that's the Paradise Centre.
Yes.
So if you've ever parked in the Paradise Centre car park, and it's really interesting legally, those, in BCCM, we all have CTS numbers. In BUGTA, we've still got BUP or GTP numbers. These ones are actually upper plan and lower plan. Upper plan is the residential bit, lower plan is the car parking. So that wasn't possible under BUGTA. So they actually had to create their own separate legislation to allow that development to happen. Then Mike Gore arrived. You know, I suppose you'd say the White Shoe Brigade. And Sanctuary Cove, which at that stage was probably just swampland, they wanted to create what it is today, which is this precinct of golf course, of hotel, of marina, of commercial shops, and residential, all in the one thing. And there was no scope at all to do that in any sensible way under BUGTA, because it just almost physically impossible to be able to stage it the way it needed. So what happened is the government created the Sanctuary Cove Resort Act, which is colloquially known by everyone as SCRA. And that allowed the creation of the development that is Sanctuary Cove today. So what happened is there's a primary thoroughfare body corporate. So that's the big beast at the top. So the members of that body corporate are the marina, are the golf course, are the hotel, are the commercial. And also, probably the single biggest member, subject to how it's structured, is what's called the PBC, which is the principal body corporate, which is effectively then, which is the overarching body which represents all of the RBCs, which are the residential bodies corporate, in Sanctuary Cove. So you've got this body corporate at the top, and then you've got these individual lots. PBC is one of them, and then underneath that, you've got all of the individual precincts or residential bodies corporate that could be 4 lots, could be 50, could be 400. And those have their own PBC meetings and all sorts of stuff. So it's sort of a body corporate within a body corporate. So what we'd know today under BCCM as a layered scheme wasn't possible under BUGTA without the advent of specific legislation. So that went off swimmingly, and then the government decided, okay, well, there's more of these things coming. So they created the Integrated Resort Development Act, which isn't a specific development act, but one that applied to any body corporate that already development that could do those sort of things. So prime examples, Hope Island, Royal Pines, those sort of things. Again, golf course, marinas, commercial, residential, PBC, and so on. And inside that PBC, you've got the secondary thoroughfare, which is all of the internal roadways inside the residential body corporate. So for those of you that have been there, you normally swipe to get into the PBC. So if you drive into Sanctuary Cove or Hope Island, you can drive straight to the commercial, the golf course or whatever, but then it's a gated community behind that usually to get to the residential bit. So that then flew along. We had a bunch of those, and then sort of there was probably a lesser version, which really is then the Mixed Use Development Act. So that's things like Koran Cove. You know, with again, so rather than have a PBC, you got a community body corporate, and individual bodies corporates are members of that. And then South Bank's probably really the last one, which is still regulated by BUGTA. So it really does, you know, Mirage up at Sheridan, Port Douglas.
We're talking about some really high-profile places in Queensland. I mean, these are places that most people would at least know by name, I'd suggest, if not actually have been there. So you hit upon a few there. Talked about Sanctuary Cove, Frank, Hope Island, Royal Pines, Mirage, Port Douglas, Laguna Keys, Kingfisher Bay over at Fraser Island is covered. We also have, as you said, Koran Cove, Cathedral Place here in Brisbane in the Valley. Brett's Wharf, Central Brunswick, that whole complex is under mud. You've got the night markets up in Cairns as well, yes. Covered. And as you said, the Paradise Centre on the Gold Coast is part of that, as well as South Bank, which is probably arguably the biggest of it all, I guess. Frank?
Yeah, I think when you look at Sanctuary Cove and probably the individual Erda resorts, they'd be bigger. But you go to a precinct like South Bank, so even South Point, the new Anthony John development down there, that sort of the Emporium's moved across. That's BUGTA, you know. So there's a bunch of buildings that are still regulated by this, and the question, Chris, is why.
Why indeed? I think your little historical overview there, Frank, apart from being fascinating, and it was, kind of sets up a bit of the why, because historically government took it upon itself to regulate things specifically. So was there a particular development or serious development? Well, we set up some legislation for that. Whereas the more contemporary way of regulating things, and particularly for community living, is to have this one piece of legislation with a few modules sitting off it to try and cover those differences that way, and to try and introduce a set of consistency around it. Why has it been that way? I think over time, government has attempted to migrate BUGTA and all of those other acts that Frank listed off, has over time attempted to migrate it that way. But I think over time, for various reasons, that's been put in the too hard basket. Number one, but number two, there's probably, Frank, a bigger reason, isn't there?
I think so. And the reality is that BUGTA itself is almost a version, I suppose, of the modules in terms of it creates the day-to-day management, like meeting notices and all that sort of stuff. But most of these bodies, well, all of these bodies corporate are really created under those other pieces of, so ERDA, SCRA, Mixed Use Development Act, and those sort of things. And those pieces of legislation give bodies corporate effectively almost a degree of planning control over what goes on in those buildings. So for interest, slow down. So when you want to do a development inside Sanctuary Cove, or any ERDA development, what there is inside that body corporate is a thing called the Development Control Bylaws. So those are approved by government, they're gazetted, and those DCBLs, so there's another acronym, they regulate how development goes on inside those individual precincts. So that's effectively where the planning control is. So they have setbacks and colours and height restrictions and all that sort of stuff. So effectively, the planning is moved from local council, which is where it is for everyone else, into the body's corporate. So when you make one of these applications to the Architectural Review Authority under the DCBL, so here's all these acronyms that get confusing, it's the body corporate that effectively signs off on the planning. So one of the issues always is in terms of the development of these things and the management of that development, it sits within the body corporate sphere. And so if you wanted to go and take, you know, for example, Sanctuary Cove, and I keep using an example, Royal Pines, it doesn't really matter. If you wanted to take that whole precinct and shift it back to Gold Coast City Council and say, okay, here you go, you're now in control of the planning for this, it would be a disaster for council because their planning rules would be inconsistent with what the body corporate has been using, and how to meld those two together and give people certainty would be really difficult. And I think that's one of the big things.
One of the other sort of quirky, if you like, points about this whole discussion is that responsibility for all of those acts that you've talked about there, Frank, does not sit with just one minister and does not just sit with the Attorney General. So the Attorney General has responsibility for body corporate and community management, Commissioner's Office, we'll get to that in a minute. But when it comes to these acts, it's actually split across several different ministers. So the Attorney General has some responsibilities, but the Minister for Natural Resources and Mines and Energy has responsibility for some of those pieces of legislation, and the Minister for State Development has responsibility for them as well. So it's not simply the case that you've got the Attorney General with some overarching responsibility here. There's actually a lot of different players in this space. A lot of different players with a lot of different interests, a lot of vested interests at that. So it's almost like having 3 or 4 different versions of the BCCM Act with 3 or 4 different ministers. If you can imagine how challenging it would be to corral those interests over a period of time, then that might also help to understand why BUGTA continues to be this legacy, if you like, moving forward. It's not a simple thing. There's actually a couple of questions here, which we'll get to. One there about if you have a body corporate from Shelley. Thanks for tuning in, Shelley. If you have a body corporate that does not want to change from this act to the new act, is there a way to do that? No, there's not at the moment. Nope. You are stuck. You are stuck until such time as government makes a decision to effectively migrate all of those provisions over to the Body Corporate and Community Management Act. We'll get to that in just a little bit further. What are some of the differences then? So, okay, so we've talked about this magnificent set of abbreviations and different buildings and all the rest of it. So what? I hear you cry. Where does the difference lie? Well, there are some pretty key differences. And I think, Frank, one of the big differences is around the dispute resolution process. the big difference is that there are no adjudicators, and indeed there's no commissioner under BUGTA. So I'll just remove myself from this discussion. No, but that there are no adjudicators. There are referees, and that too is a legacy issue. So the genesis of what we now know to be the Commissioner's Office was back in the Department of Natural Resources, where you had, I think it was actually called the Referee's Office. I can't quite remember. I think even Tasmania to this day continues to operate a referee system, similar to how Queensland used to do it. So you had the referees, and then when you had the BCCM Act come into force in 1997, it migrated over into a Commissioner's Office. But of course, all these other things got left behind. So the way it works now is that we have the Commissioner's Office resolving disputes, but they also resolve BUGTA disputes, but they resolve it in terms of a referee system. It's very different, Frank, isn't it, to
it's enormously
adjudication?
Jurisdictionally, it is a nightmare in the sense of actually getting in there to a degree. So when you look at BCCM, the Commissioner's Office has primary jurisdiction for every dispute between lottos and a body corporate. End of story. But under BUGTA, it's not that simple. So even enlivening the jurisdiction to a degree becomes difficult. And I suppose BUGTA's, it's terrifying, not terrifying. You've got to, every single time a BUGTA issue comes up, you've got to go and effectively reread the Act because there's gaps in it. So to me, what they did with BCCM was they cured a lot of the holes that were in BUGTA, but they've never actually gone back and retrofilled BUGTA to fill those same holes. So it's sort of, while you and I could probably sit here and rattle off BCCM sections, and I suppose the modules will change a little bit on the 1st of March, those section numbers might go around a little bit, but the concepts are there. Every time I get a BUGTA question, I've still got to go back and double check, because it's not just off the top of my head type stuff. And certainly referees and disputes are absolutely that.
So yeah, so the referees operate very differently to adjudicators. They basically run the cases in the Commissioner's Office, and they take carriage of it all the way through. One of the other big differences, as I said, there's no commissioner, so the commissioner doesn't have a role. There's no conciliation either under BUGTA disputes. It's straight to a referee to determine. There can be, in some very, very, very rare cases, the ability for a conciliator to get involved, but doesn't happen really. One of the other big differences is that the 1-800 number that everyone would know in the Commissioner's Office, where you ring and you can get a bit of information about legislation, you can't do that if you are living in a BUGTA related scheme. And so the way it works is in that office, you call and you sort of, even if you don't reveal up front that you're from a BUGTA scheme, it eventually will come out in the conversation. It has to, because there is some difference in language. And at that point, the information service says we can't assist you because they are not empowered under legislation to assist. So there is no free call service for BUGTA related queries in Queensland, which is pretty unfair when you think about it, Frank. Grossly unfair.
Because it's fair. It is complex.
Very. One of we talked a bit about language and terminology. One of the big terminology issues is that under BUGTA we talk about proprietors, not lot owners. We talk about proprietors, and those differences repeat themselves throughout the legislation. Interestingly, we talk a lot about reasonable decision making under BCCM. There's no concept of reasonable decision making, is there, Frank, in this situation?
Nope. So, and you talk about the holes that are left in BUGTA that aren't in BCCM, and we bang on endlessly about Section 180. So Section 180 of the Act is effectively the where the government has seen fit to prohibit bylaws differentiating between types of owners or occupiers, preventing transmissions of lots, regulating the use of lots, short-term, long-term purposes, and those sort of things. Those things don't exist under BUGTA. So therefore, when you come to prohibiting short-term letting, which was the thing that was on the media, well, it's probably the start of this year, I lose track of time with COVID, where a body corporate inside Hope Island called Fairway Island was held to have lawfully prohibited short-term letting under their bylaws because there's no prohibition under BUGTA for that, for bylaws to prevent that, whereas there is under BCCM. So there's a lot of confusion around that. You know what I mean? So it's this reasonableness concept, the statutory provisions change, and even you come into management rights, for example. There are management rights in BUGTA buildings. To enter into a letting agreement under BUGTA, you need to have a bylaw that actually allows the body corporate to resolve to do that. You don't need that under BCCM because the Act actually includes it. So, you know, it's sort of the ability for bodies corporates to effectively take control of more of their own decision making through their bylaw making power is a really interesting thing. But even, I mean, people that are in there, if you've bought it, it's a completely different conveyancing process. There's no disclosure. It's not a Section 206. It's a Section 40 certificate. And even trying to understand where all the bylaws are under BCCM, there's a CMS, which is the consolidated document that has all of the bylaws. Under BUGTA, they're registered over time. Here's bylaws 1 to 50, and then we delete bylaw 44 and replace it with this, and then we amend bylaw 17A to be this. Those, to get the bylaws, you've got to get copies of all of those documents. So there's things like that in theory, I think would be easy enough to sort of transfer across, but it's just never been done. And I suppose, Chris, one of the reasons why are probably on the lines of there's, I don't know, 50-odd thousand strata schemes in Queensland. I don't know, in terms of strata residential BUGTA schemes, it's going to be less than 1,000. So it's not really high on a political agenda to deal with it.
Yeah, which goes towards answering your question, Marie, and you've got a few there. Thanks for tuning in too. So why hasn't it happened? It's not been a priority for government up until this point. So there has been attempts over time. Recently, it's just a couple of years ago, not even a couple of years ago, maybe, a paper was issued about that process. This was under the Property Law Review, with one of the products of which is the new regulation modules that we've talked about. There was a paper put out by Queensland University of Technology to make that change, to bring BUGTA schemes into line with BCCM. Government has not adopted any of those proposals at this time. And to be frank, I don't think it's a priority of the government moving ahead. I could be wrong. We might be wrong. We might find out that there will be those changes. It hasn't happened yet. So, and then in answer to your question, Marie, the government needs to get involved. It's a political issue now. So if you want reform in this area, it's a political issue and you need to advocate to government for that reform. And yes, you can be stopped doing short-term letting potentially under BUGTA. The same kind of provisions that apply under BCCM don't apply under BUGTA.
And what
Daniel,
I caveat that in terms of what the bylaws actually say needs to be very specific and clear, but there is the ability for bodies corporates to prevent it.
Definitely. Daniel, thank you for tuning in as well. Is there a conflict of interest provision for committee members? I don't think there is under BUGTA, Frank, off the top of my head.
And again, this is one of those scary ones with BCCM. Absolutely know it backwards. BUGTA, off the cuff, I don't know. You'd have to go and actually look at the legislation. So, and then that's probably where, in a sense, sometimes BUGTA-wise, you've almost got to overlay, and I suppose, Chris, this is back to good corporate governance, is declaration of conflicts and dealing with them and noting them and absolving yourself from decision-making should happen. But it's not necessarily a statutory imposition under BUGTA a lot of the time.
Yeah, and so some of the questions, really appreciate the questions that everybody's asking, but it's very difficult for Frank and I to give any kind of clear answers to these because there are very much not clear answers on a lot of these questions, which kind of leads us to the final thing that I wanted to talk about in our discussion today. So, okay, you're involved in a BUGTA related scheme in one way or another. What are the key takeaways that we think that you should take away from this discussion? Well, the first one, it's a really specialised area, very specialised. It's absolutely vital to get qualified advice and qualified assistance. And
it's, terrifyingly complex. It's the gaps. It's the gaps you're not aware of that BCCM otherwise would deal with that BUGTA doesn't, and you need to know where to go. So it's never a 2-second answer to a BUGTA question in my experience.
We have some very good BUGTA related practitioners at this firm, I have to say.
Yes.
Just putting it out there. The second part of it goes back to my point about strata law reform. So it may address some issues, but it is seemingly a long way off. And Michael, thank you for tuning in, Michael. Michael observes that he's been or was involved with a meeting of government and the policymakers who said it was too hard to update and resolve the differences at play. There you go.
And there's part of it that says to me, even the difference in general meeting notices, 7 days under BUGTA versus 21 under BCCM, it's not that hard to reconcile some of those very basic things.
Yeah.
But here we are.
Probably the final point that I would make is that the dispute resolution process under BUGTA is pretty cumbersome, pretty involved. It's not anything like you might be used to or expect in any other circumstance. So maybe there is actually a good case for considering some alternative dispute resolution options in a BUGTA sense, mediation, facilitation, because think about it this way: if you have to take a dispute to a referee and the referee makes an order, that can then be appealed to effectively the magistrate's court. And then in turn can be appealed to the Supreme Court. Do you want to do that? Do we want to go to the Supreme Court with our issue? I wouldn't have thought so, Frank.
No, and I think that's probably, obviously you don't see, to a degree, I think BUGTA is almost like strata in other states. So as much as people can be critical of the Commissioner's Office, I think it serves a spectacular purpose in terms of helping people understand strata, which is complex in itself, helping people get through the resolution of disputes via conciliation or even adjudicators in a relatively timely manner without having the big overlay of court. Whereas if you go to effectively any other state, you go to New South Wales, if you want to have a dispute, a strata dispute in New South Wales, you're off to NCAT, which is our QCAT equivalent, which is basically a court. It's constituted by members, but there's legal processes. There's, it's not a easy thing to navigate, and it's certainly more intimidating. BUGTA, to a degree, is our version of that. And you wouldn't call it, it's not simple, but what it does, it makes it harder to get resolution of disputes. So there's not anywhere near as many decided decisions in relation to BUGTA disputes as there are BCCM ones, just by virtue of that ease of access. Mm-hmm. So that's where there's still, to me, a lot of interpretive difficulties, because not everything has been ventilated ad nauseum, because the Commissioner's Office does give the ability to get into there and have a decided dispute in a relative sense pretty easily, where it's different from everything else, and BUGTA's still stuck in that regime. BUGTA buildings.
Yeah. Question from Karen: can the CBC under MUD force the subsidiary BCs to stop short-term rentals? Potentially, but we go back to Frank's point before. It really does depend on the bylaws that we are talking about. But I suppose the point to make there is that while short-term letting under BCCM is pretty much open and not restricted, not the same under the BUGTA related
No, and then you're looking jurisdictionally, it's sort of the CBC is then trying to regulate what goes on inside people's lots inside their own subsidiary bodies corporate. So whether that is lawful under MUD, depends on MUD, depends a little bit on BUGTA. And I suppose the question there from Daniel at the end, can a BUGTA body corporate go bankrupt? I don't think so. But I'm aware, like Laguna Keys, for example, there were receivers appointed, I think, to that principal body corporate or the PTBC at one stage over water bills and all that sort of stuff up in central Queensland. So, but I think where it gets to is that effectively, and again, I know under BCCM, what a body corporate cannot be insolvent. It must strike a special levy on its members to the extent it can't effectively pay what it has to pay. And I think BUGTA buildings, I'd suspect, would be the same. But again, that's very much caveated. I love giving absolute answers, but I just don't know off the top of my head. It's just so different.
Several, but there's actually quite a lot of questions here on this one. So I think obviously
that's reflective of the lack of ability to get answers elsewhere.
Yep.
So I'm really sorry, ladies and gentlemen. I'd love to be able to run through them all and be precise, but it's just I'd need to go and check is the reality. I'm just not that confident to shoot from the hip, which I'm sometimes capable of doing.
Yeah. Daniel, can we have another BUGTA Q&A, please? Well, we can, but the same issue that Frank just mentioned arises again. Our ability to give definitive answers about BUGTA is pretty limited, I got to say, in some cases.
In this forum, happy to give written advice, which is what we do. And I mean, the big dispute at Coran Cove, one of our litigators is in the middle of. So, and even for her, it's just a matter of, you've just got to double check everything. Jurisdictionally, spending limit wise, how the legislation overlays with MUD and BUGTA itself, and decision making and special resolutions and CBCs. It can be really, it is really complex. And Marie, you're right. You talk to government.
If you want change in this area, you do need to be lobbying government. Now is the time to do it, when the government is still new and still fresh, and hopefully flexible in setting its agenda. We've come to the end. Gosh, who knew BUGTA would take up so much time? But there it is. It's just flying, as it always does. Thanks, everyone, for tuning in. There's obviously a lot of interest, and I think that's reflective of the complexity of it all, as you said, Frank. So stay tuned. We may get around to doing something similar in the future as well. But in the meantime, if you do have a BUGTA-related query that you think that we can assist with, drop us a line to the email address on the screen there. Frank, as always, it's been a pleasure.
As always, mate. So 1 to go this year.
1 to go. Next week is our final webinar for 2020, and we will be looking into the future.
Yes. What does 2021 hold for Strata? Not for everything else, because I got no idea about the world at large, but Strata got some ideas. Yeah.
Stay tuned for that one. It'd be great to have you all tune in for the final webinar of 2020. In the meantime, don't forget to like and share. Drop us a line if you need to. We'll see you next week, everyone.
Thanks,
Talk to you later.
Bye.
Bye.